when I bought the 15-acre property outside Scottsdale, Arizona. The first thing I fell in love with was the 3-acre pond nestled in the southeast corner of my land, fed by an underground spring that had been flowing for probably hundreds of years. I'm Vincent Fitzgerald, a software developer who'd made enough money in my early 30s to finally escape the cramped apartment lifestyle and buy myself a piece of actual paradise. The property had been in the same family for generations, completely off-grid, and the previous owners had used that pond to irrigate a small orchard and vegetable garden that I planned to maintain. The day I moved in, I spent hours just sitting by that pond, watching dragonflies skim across the surface and listening to the bullfrogs start their evening chorus. The water was crystal clear, fed constantly by that spring, and it overflowed into a small creek that meandered across my property and eventually onto the neighboring land. I didn't think much about where that overflow went. Why would I? It was my land, my water source, and according to every property survey and title document, that pond sat squarely within my boundaries. 3 weeks after I moved in, I got my first visit from the HOA president. Her name was Brenda Patterson, and she arrived in a white Mercedes SUV that looked like it had never seen a speck of dust. She was maybe 55, with that particular haircut that screamed, "I want to speak to the manager," and designer sunglasses that probably cost more than my first car. I was out working on the irrigation system when she pulled up, and I wiped my hands on my jeans as I walked over to greet her. "You must be the new owner," she said, not offering her hand. "I'm Brenda Patterson, president of the Saguaro Heights Homeowners Association." I felt my stomach drop. HOA. I specifically looked for properties that weren't part of an HOA. "Well, technically your property isn't," she said with a smile that didn't reach her eyes. "But the previous owners had an agreement with us regarding water usage from the pond. I'm here to discuss the continuation of that arrangement." I pulled out my phone and opened the folder with all my property documents. "I have the complete sale records here. There's no mention of any agreement or easement regarding the pond." Brenda's smile tightened. "It was an informal arrangement. The overflow from your pond feeds the irrigation system for our community. There are 47 homes in Saguaro Heights that depend on that water for their landscaping." "That's not my problem," I said, trying to keep my voice level. "The pond is on my property. The spring feeds it. If there's overflow that happens to run onto other land, that's just natural water flow, but I didn't agree to maintain it for anyone else's benefit." "I think you'll find that we have certain rights," Brenda said, her voice taking on a sharp edge. "Water rights in Arizona are quite complex. I'd hate for this to become a legal issue. If you want to discuss water rights, you should speak with a lawyer," I told her. "I'm not interested in binding myself to agreements that weren't disclosed during the property sale. If the previous owners had a deal with you that ended when they sold to me." Her face flushed red. "We'll see about that, Mr. Fitzgerald. We'll see about that." She climbed back into her Mercedes and peeled out, sending gravel flying. I stood there feeling uneasy. I'd bought this property specifically to avoid HOA nonsense, and here it was, finding me anyway. 2 days later, I received a certified letter from the Saguaro Heights HOA. I opened it at my kitchen table, my coffee growing cold as I read through the legal jargon. They were claiming that the pond, despite being entirely on my property, was considered a community water resource, and that I was required to maintain it according to their specifications. They demanded access to the pond for routine inspection and maintenance, and insisted that I could not alter the water flow in any way that would impact the irrigation system serving their community. I immediately called a real estate attorney named Marcus Webb, who'd been recommended by a friend. Marcus had an office in Scottsdale and agreed to see me that afternoon. "This is interesting," Marcus said, reading through the HOA letter while I sat across from his desk. He was in his 40s, with graying hair and the tired eyes of someone who'd seen too many property disputes. "They're trying to establish an easement by prescription." "In English?" I asked. "Basically, they're claiming that because the previous owners allowed them to use the water for so long, they now have a legal right to continue that use. In Arizona, if someone uses your property openly and continuously for 10 years, they can sometimes establish legal rights to continue that use." "Can they actually do that?" Marcus leaned back in his chair. "It depends. Do you know how long the previous owners allowed this arrangement?" "The family owned the property for over 50 years, I said, "but I have no idea when this water arrangement started." "That's what we need to find out. But here's the thing, Vincent. Even if they could prove long-term use, prescriptive easements have specific requirements. The use has to be hostile, meaning without permission. If the previous owners gave them permission, that actually works against the HOA's claim. So what do I do? First, we send them a response denying their claims. Second, we do some research. I want to dig into the property records and see if there's any documented agreement. Third, and this is important, you need to document everything. Every interaction with the HOA, every piece of correspondence, everything." I left Marcus's office feeling slightly better but still anxious. I'd bought this property to find peace, not to fight legal battles. The next week was relatively quiet. I continued working on my house, setting up my home office, and getting the garden area ready for spring planting. The pond continued to flow as it always had, the overflow trickling into the creek that crossed into HOA territory. Then I got my second visit from Brenda, except this time she brought friends. I was replacing some rotted boards on my back deck when I heard vehicles approaching. 3 cars pulled up, all expensive SUVs. Brenda emerged from the lead vehicle, along with 4 other people, 3 women and 1 man, all dressed like they were heading to a country club. "Mr. Fitzgerald," Brenda called out, "we need to discuss this situation like reasonable adults." I set down my hammer and walked over, mentally recording everything just like Marcus had advised. "What can I do for you, Miss Patterson? These are members of our HOA board," she gestured to her companions. "This is Linda Morrison, our treasurer, Gerald Hutchins, our secretary, and Cheryl Wilson and Patricia Haynes, both board members." I nodded to each of them. They all had the same look, that particular combination of entitlement and irritation that came from people used to getting their way. "We've received your attorney's letter," Brenda continued. "And frankly, we're disappointed. The previous owners, the Chen family, were wonderful neighbors who understood the importance of community cooperation." "That's great," I said, "but their agreements don't transfer to me unless they're in writing and recorded with the property deed." Linda, the treasurer, stepped forward. She was probably in her early 60s, with perfectly manicured nails and jewelry that caught the afternoon sun. "Mr. Fitzgerald, perhaps you don't understand the situation. Our entire community's landscaping depends on the water from that pond. We've invested millions of dollars in our homes and grounds. You can't just cut us off." "I'm not cutting anyone off," I pointed out. "The water flows naturally. I'm just not agreeing to maintain it for your benefit or give you access to my property." "That pond is really community property," Patricia chimed in. She was younger than the others, maybe 45, with blonde highlights and an aggressive stance. "Just because the property lines say it's on your land doesn't mean you own the water." I took a deep breath. "Actually, in Arizona, I do own the water from a spring on my property. I've done my research." "We'll see what a judge says," Brenda snapped. "We're prepared to file a lawsuit if necessary." "Then file it," I said, surprising myself with my firmness. "But until a court tells me otherwise, this is my property, and I'll manage it as I see fit." Gerald, the only man in the group, finally spoke up. He was heavyset with a red face that suggested high blood pressure. "You're making a big mistake. You have to live out here. It would be a shame if you found yourself isolated, with no one willing to help if you needed it." "Is that a threat?" I asked. "It's a statement of fact," he replied. "Communities work when people cooperate." "I'd suggest you all leave my property now," I said. "Any future communication should go through my attorney." Brenda's face turned an impressive shade of crimson. "You're going to regret this attitude, Mr. Fitzgerald. We have resources. We have influence. You're just one person." They left, but the encounter shook me more than I wanted to admit. I immediately called Marcus and told him about the visit, especially Gerald's thinly veiled threat. "Document it," Marcus said. "Write down everything they said while it's fresh. If they keep harassing you on your property, we can pursue a restraining order." That night, I couldn't sleep. I kept thinking about what Patricia had said, that the pond was really community property. The entitlement was staggering. These people actually believed they had a right to resources on my land just because they wanted them. The next morning, I decided to do some investigating. I drove over to the Saguaro Heights development to see exactly how they were using my water. The development was one of those upscale desert communities, all southwestern architecture and carefully manicured xeriscaping. Despite the native desert plants, they'd clearly put significant resources into irrigation. Everything was too green, too perfect. I parked on a public road and walked along the perimeter. That's when I found it. A professional irrigation system with a pump station pulling water from the creek that flowed from my pond. They'd built an entire infrastructure around my water, complete with a large storage tank and distribution pipes running throughout the community. I took photos of everything, making sure to document the pump setup, the storage tank, and the pipes. This wasn't just casual use of overflow water. They'd built a whole system assuming they'd have permanent access to water from my property. Back home, I sent the photos to Marcus. He called me within an hour. "This changes things," he said. "They've made significant improvements based on access to your water. That's going to make them more aggressive about defending what they see as their rights." But it also shows that this was a structured arrangement, not just natural water flow. We need to find out if the Chen family gave them permission to build this infrastructure. How do we do that? I'm going to track down the Chens and see if they'll talk to us. In the meantime, you need to be careful. People who invest this much into something don't give it up easily. Marcus was right to warn me. 3 days later, I woke up to find a notice posted on my front door. The Saguaro Heights HOA had filed a lawsuit seeking to establish an easement over my pond and the creek, claiming prescriptive rights based on over 20 years of continuous use. Reading through the lawsuit with Marcus, I learned that the HOA claimed the Chen family had verbally agreed to the water arrangement in 1998, when the development was first built. They had statements from the original HOA president and several longtime residents attesting to this agreement. "Here's our problem," Marcus explained. "If they can prove they've been using the water openly and continuously since 1998, and that their use was based on permission from the landowner, it becomes complicated. Arizona law doesn't generally allow prescriptive easements when use is permissive, but they might argue that the arrangement became so established that you should be required to honor it." "That's insane," I said. "I bought this property. Nothing in the disclosure mentioned this arrangement." "Which is actually a good point," Marcus said. The sellers had a legal obligation to disclose any agreements affecting the property. The fact that they didn't might mean the arrangement wasn't as formal or binding as the HOA claims. I'm still trying to reach the Chen family. While the legal process ground forward, life at my property became increasingly uncomfortable. I started noticing vehicles slowing down as they passed my driveway, clearly watching my property. Twice, I found people walking near my pond who claimed they were just hiking, despite the private property signs I'd posted. Then the violation started. The first citation came in my mailbox, an official-looking notice from the Saguaro Heights HOA claiming I'd violated community standards. I called Marcus immediately. "They're fining you for what?" he asked, incredulous. "Improper storage of building materials, unsightly property maintenance, and unauthorized agricultural activities," I read from the notice. "They're demanding I pay a $500 fine and correct the violations within 7 days. Vincent, you're not part of their HOA. I know that. You know that. Apparently they don't care." I threw the citation in the trash, but more kept coming. Every few days, a new violation notice appeared, each with escalating fines. Overgrown vegetation, unauthorized structures, improper fencing. They were making up violations to harass me. Marcus sent them a cease and desist letter, clearly stating that I was not a member of their HOA and not subject to their regulations. They responded by amending their lawsuit to claim that my property should have been included in the HOA boundaries when the development was created, and that the exclusion was an administrative error. "Can they actually do this?" I asked Marcus during one of our increasingly frequent phone calls. "They can file whatever they want," he said. "Doesn't mean they'll win, but it costs them nothing but legal fees and it costs you stress and time. It's a pressure tactic." The pressure got worse. In May, about 3 months after I'd moved in, I noticed the water level in my pond dropping. Not by much, just a few inches, but enough to notice. I checked the spring and it was flowing normally. I checked the overflow to the creek, and that's when I found the problem. Someone had dug a new channel, diverting more water from the overflow into the creek that fed the HOA's system. They'd done it cleverly, making it look almost natural, but it was definitely new. I took photos and called the sheriff's department. Deputy Rachel Morrison showed up within an hour. She was in her 30s, professional and thorough. I showed her the diversion and explained the ongoing dispute with the HOA. "This is your property," she confirmed. "Yes, madam, completely within my boundaries. And you didn't authorize this work." "Absolutely not." She took her own photos and filed a report. "This is criminal trespass and vandalism. Do you have any idea who did it?" "I can guess, but I can't prove it." "We'll investigate," she promised. "In the meantime, I'd suggest getting some cameras set up. If someone's willing to do this, they might try other things." I spent that afternoon installing a security camera system around my property, focusing on the pond and the overflow area. The cameras had motion detection and night vision, and they uploaded footage to cloud storage. Good thing I did. 2 nights later, the cameras caught 3 people trying to install a new pump on my creek. The footage was clear enough to identify them, all residents of the Saguaro Heights community. I called Deputy Morrison immediately. She arrived with another deputy, and they went to the addresses I'd identified from the HOA directory I'd found online. The 3 residents claimed they were acting on instructions from the HOA board, who had told them they had legal rights to access the water. "Interesting defense," Deputy Morrison told me later. "They're claiming they believed they had permission because the HOA told them so. We're still investigating, but it's turned into a mess of civil versus criminal issues." Meanwhile, Marcus finally tracked down David Chen, the son of the family that had sold me the property. David agreed to meet with us at a coffee shop in Scottsdale. David was in his 50s, a calm, soft-spoken man who worked as an engineer. My parents sold that property because maintaining it became too much after my father's stroke, he explained. They moved into an assisted living facility in Phoenix. Did they have an agreement with the Saguaro Heights HOA about water? Marcus asked. David sighed. Not exactly. When the development went in, the HOA approached my father. They wanted to use the overflow from the pond for irrigation. Dad didn't see the harm. It was just water that was flowing off the property anyway. But he never signed anything. It was just a verbal sure, I don't mind. Did they ever discuss making it formal? I asked. The HOA brought it up a few times over the years. They wanted my dad to grant them an official easement. He always refused. He said if they wanted a legal guarantee, they needed to pay for it, like renting the water rights. They never wanted to pay. They just kept using the water, and Dad never pushed back because he didn't care enough to fight about it. So it was always permissive use and never formalized, Marcus summarized. Exactly. And honestly, we should have disclosed it when we sold to you. But it had just become such a background thing, none of us even thought about it. The HOA never paid anything, there was no paperwork, it was just something that happened. I'm sorry you're dealing with this mess. This was exactly what we needed. Marcus drafted an affidavit for David to sign, detailing the informal nature of the arrangement and his father's consistent refusal to formalize it. With this evidence, our legal position strengthened considerably, but the HOA wasn't backing down. In June, they filed an emergency motion claiming that I was threatening to cut off their water supply, and that this would cause immediate and irreparable harm to their community. They asked the judge to issue a temporary injunction requiring me to maintain the water flow while the case proceeded. The hearing was scheduled quickly. I sat in the courtroom next to Marcus, watching Brenda and her high-priced legal team present their case. Their attorney, a sharp-dressed man named Richard Kellerman, painted me as an unreasonable newcomer who was threatening an established community. Your Honor, Kellerman argued, the residents of Saguaro Heights have relied on this water source for over 25 years. They've invested millions of dollars in their homes and landscaping based on the availability of this irrigation water. Mr. Fitzgerald is essentially holding the community hostage. Your Honor, Marcus countered when it was our turn. Mr. Fitzgerald owns the property. He owns the spring. He owns the pond. The HOA has never paid a single dollar for the water they've been using. They've never had a formal agreement. This was always a permissive arrangement that the previous owner could have revoked at any time, and that permission didn't transfer to my client. Judge Catherine Reynolds was in her 60s, with sharp eyes and a no-nonsense demeanor. She listened to both sides, reviewed the evidence, and then made her ruling. I'm denying the motion for a temporary injunction, she said. Mr. Fitzgerald has property rights that are clearly established. The HOA has failed to demonstrate that they have any legal entitlement to the water. However, I'm going to expedite the trial on the underlying easement claim. We'll resolve this matter fully and quickly. Trial is set for September 15th. Brenda looked like she'd swallowed a lemon. As we left the courtroom, she cornered me in the hallway. You're destroying property values, she hissed. You're hurting innocent families. I'm protecting my property rights, I replied. You had years to formalize this arrangement with the Chens. You chose not to because you didn't want to pay for it. That's not my problem. We'll see what the trial brings, she snapped. Over the summer, the harassment intensified. The HOA put up a billboard on the main road into Scottsdale, claiming there was a water crisis in Saguaro Heights caused by an unreasonable landowner. They didn't name me specifically, but everyone in the area knew what it was about. I started getting hate mail, anonymous letters calling me selfish, greedy, and worse. Someone spray-painted "water thief" on my mailbox. The sheriff's department investigated but couldn't find who did it. The security cameras caught more attempted trespassing. The HOA had apparently told residents they could inspect the pond, and several people tried to walk onto my property. I had to call the sheriff's department 4 times in July alone. Then things got serious. In early August, I woke up to find that someone had tried to poison my pond. There were dead fish floating on the surface and empty chemical containers on the shore. The cameras had caught 2 people in masks dumping something into the water around 3 in the morning. This time, the sheriff's department took it very seriously. Deputy Morrison brought detectives with her. "This is environmental vandalism," she told me. "Possibly attempted poisoning of a water source. If they'd succeeded in killing the spring, it could have been much worse. We're treating this as a serious crime." The chemical containers were traced to a purchase made by Patricia Haynes, one of the HOA board members I'd met during that first confrontation. When detectives interviewed her, she cracked immediately, admitting that Brenda had suggested making the pond unusable, so I'd have no reason to fight the HOA over it. Brenda and Patricia were both arrested and charged with criminal mischief, trespassing, and environmental crimes. The story made the local news, and suddenly public opinion shifted. What had been portrayed as a dispute between a community and a difficult landowner now looked like what it was: harassment and criminal activity by an HOA gone rogue. The arrests changed the dynamics of the lawsuit. The HOA's insurance company got involved and pushed for settlement. Their attorney contacted Marcus with an offer. The HOA would drop all claims to the pond and water rights if I agreed not to pursue a civil lawsuit for the damages and harassment. "What do you think?" I asked Marcus. "Honestly." "I think we should counter. They put you through hell. They committed crimes. Their board members are facing criminal charges. We have leverage." We countered with our own terms. The HOA would drop all claims, publicly acknowledge my property rights, pay for the cleanup of the pond after the poisoning attempt, reimburse my legal fees, and pay $50,000 in damages for the harassment and decreased enjoyment of my property. After some back and forth, they agreed. The settlement was finalized in late August, just before the scheduled trial. I thought that was the end of it. I was wrong. In early September, just after the settlement was signed, I noticed the water level in the pond dropping again. This time, it wasn't a diversion someone had built. The water was just going down. I checked the spring and found that someone had tried to block it with concrete and debris. This was too much. I called Deputy Morrison, but I also made a decision. If the HOA wanted a war over water, I'd show them what that actually meant. I hired a contractor and explained what I wanted. Over the next week, we installed a recirculating system that captured all the overflow from my pond before it reached the creek. The water would cycle through my irrigation system and back into the pond. Not a drop would leave my property. We also cleared the debris from the spring and installed protective barriers to prevent future tampering. The spring flowed strong again, filling the pond back to its normal level. The effect on Saguaro Heights was immediate. Without the overflow from my pond, their irrigation system had no water source. The pumps ran dry. Their carefully maintained landscaping began to suffer in the September heat. I got an emergency call from the HOA's attorney. "Mr. Fitzgerald, you're cutting off the water entirely." That wasn't part of the settlement. The settlement said I had sole rights to my water, I replied calmly. I'm exercising those rights. After someone tried to sabotage my spring, I decided I needed to protect my water source. But the overflow, that's just natural drainage. Not anymore. I've installed a recirculation system. It's all used for irrigation on my property now. Perfectly legal use of my own water resources. There was silence on the other end. This is going to cause serious problems for the community. Then the community should have thought about that before trying to poison my pond and block my spring. I have those incidents documented, by the way. The criminal cases are still pending. What do you want? I want to be left alone, I said. That's all I've ever wanted. The attorney hung up. 2 hours later, Brenda called me directly. Please, she said, and her voice sounded different, smaller, without the aggressive edge. People's landscaping is dying. Property values are dropping. Can we talk about this? Why would I trust anything you say? I asked. You've lied, harassed me, trespassed on my property, and orchestrated criminal acts against me. I know we went too far, but there are 47 families here. Most of them had nothing to do with what happened. They're innocent. They elected you, I pointed out. They supported the lawsuit. They put up that billboard. Don't pretend they're all innocent bystanders. What would it take, she asked, for you to let some water flow again? I thought about it. I thought about the months of stress, the legal fees, the vandalism, the poisoning attempt. I thought about the arrogance of people who thought they could just take what belonged to someone else because they wanted it. Here's the deal, I said finally. The HOA pays me for the water. A formal lease agreement drawn up by attorneys, recorded with the county. Fair market rate for water rights in Arizona. The lease includes specific limitations on usage and access. No one from the HOA ever sets foot on my property without written permission. Any violation of the lease terms and it terminates immediately. How much are we talking about? $3,000 a month. That's cheap for the volume of water you were using. That's $36,000 a year. That's the cost of having your own water infrastructure, I said. You've had free water for 25 years. Consider it catching up on back payments. The HOA will never agree to that. Then your landscaping will die. Your choice. She hung up on me. For 2 weeks, nothing happened. I watched from my property as the Saguaro Heights landscaping turned brown. Some residents tried to water with city water, but that was expensive and couldn't match the volume they'd been getting from my pond. The news picked up the story again, framing it as a cautionary tale about HOA overreach. Then I got a call from a different attorney, one representing a group of Saguaro Heights residents who wanted to remove the current HOA board. They asked if I'd be willing to meet with them. I met with 5 residents at a neutral location, a conference room at a local library. They introduced themselves, all longtime residents who were horrified by what the board had done. We didn't know about the poisoning, said a woman named Jennifer Sanders. When that came out, a lot of us were shocked. That's not what we signed up for. We've started recall proceedings against the entire board, added Mark Rodriguez. We're also exploring criminal complaints for misuse of HOA funds since they spent community money on this crusade without proper authorization. What do you want from me? I asked. A reasonable water agreement, Mark said. We understand we don't have a right to your water. We understand that what the board did was wrong, but we also have families and homes here. We're asking for a fair deal. I looked at these people, and they seemed genuinely different from Brenda and her cronies. I offered the current board a lease agreement at $3,000 a month. We think that's fair. We'd like to accept that offer if you're still willing. Over the next month, we negotiated the details. The new HOA board, elected after the recall, was much more reasonable. We agreed on a 5-year lease with options to renew. The monthly payment was set at $3,000 with annual adjustments for inflation. The agreement included strict terms about access, usage limits, and environmental protection. The HOA also agreed to install water meters so we could track exactly how much they were using and make sure they stayed within the agreed limits. If they exceeded the limits, they'd pay overage fees. With the agreement signed and the first payment made, I adjusted my recirculation system to allow overflow again. The water flowed back into the creek, and the Saguaro Heights irrigation system came back to life. The criminal cases against Brenda and Patricia moved forward. In November, they both pleaded guilty to reduced charges. Brenda got 6 months of house arrest, 2 years of probation, and a fine. Patricia got probation and community service. Both were banned from serving on any HOA board in Arizona. The investigation also revealed that Brenda had spent over $60,000 in HOA funds on the legal battle without proper board authorization. The HOA filed a civil suit against her to recover those funds. As for the residents who tried to install the unauthorized pump and who dug the water diversion, they received misdemeanor charges and fines. The publicity around the case made them pariahs in the community. By December, things finally settled down. The new HOA board was professional and respectful. The monthly payments came in on time. The water flowed, supporting both my property and theirs. I finished setting up my orchard and expanded my vegetable garden. The pond returned to its peaceful state, with clear water and thriving wildlife. I'd sit out there in the evenings, listening to the bullfrogs and watching the sunset, finally enjoying the peace I'd bought the property for. The irony wasn't lost on me. If Brenda and the original board had just approached me respectfully in the beginning, if they'd offered a reasonable agreement from the start, none of the drama would have happened. I probably would have agreed to let them use the water for a modest fee or maybe even for free with a proper agreement in place. But their entitlement, their assumption that they could bully me into giving them what they wanted, had turned a simple negotiation into a months-long nightmare. The case became somewhat famous in HOA reform circles. I got contacted by a few news outlets and even a podcast about HOA horror stories. I did a couple of interviews, mainly because I wanted other people to understand their rights when dealing with aggressive HOAs. One interview question stuck with me. "Do you regret buying the property?" I thought about it carefully before answering. "No, not at all. This property is beautiful. It's everything I wanted. Did I expect to spend 6 months fighting legal battles and dealing with harassment? No. But I learned a lot about standing up for my rights. And in the end, everything worked out. And it had. By the time the holidays rolled around, I'd been living on the property for almost a year. The pond was pristine, my garden was thriving, and I had a steady income stream from the water lease that more than covered my property taxes and maintenance costs. The new HOA board invited me to their holiday party as a gesture of goodwill. I almost didn't go, but I decided it was worth trying to build positive relationships with my neighbors. The party was actually pleasant. Several residents apologized for the harassment, explaining they'd been misled by Brenda about the legal situation. "She told us you were trying to extort the community," one resident confessed. "She said you were demanding outrageous payments and threatening to cut us off. We didn't know the truth until the criminal charges came out." I accepted the apologies, though I remained cautious. Trust had to be rebuilt slowly. In January, I got a letter from David Chen. He'd heard about everything that had happened and wanted to apologize again for not disclosing the informal water arrangement. "I feel terrible that you went through all that," he wrote, "but I'm glad you stood your ground. My father always said that HOAs were the worst thing about modern housing developments. He'd be proud that you didn't let them bully you. I wrote back, thanking him and letting him know that everything had worked out. I also mentioned that the pond was doing well, and that I was maintaining the orchard his family had planted. Spring came, and with it, my first full growing season on the property. The fruit trees blossomed, the vegetable garden exploded with growth, and the pond supported everything beautifully. The water lease payments continued to arrive on time, and my relationship with the new HOA board remained cordial if distant. In March, I got a call from Marcus. "Remember how Brenda spent HOA funds without authorization?" "Yeah. The civil suit just concluded. The judge ordered her to repay $78,000 to the HOA. Turns out she spent even more than we thought, and she couldn't justify any of it as legitimate community business. Will she actually pay it? She'll have to. They've already started garnishing her wages and put a lien on her property. She's probably going to have to sell her house." I felt a small twinge of sympathy, but only small. Actions had consequences, and Brenda's actions had been deliberate and malicious. By summer, life had settled into a comfortable routine. I worked my remote software job from my home office, maintained my property, and enjoyed the peace of rural living. The pond remained the centerpiece of the property, a constant source of beauty and utility. The Saguaro Heights development adapted to their new reality. Some residents installed additional rainwater collection systems to supplement the pond water. Others redesigned their landscaping to be more drought-tolerant. The community actually became more sustainable and less dependent on any single water source. In August, almost exactly a year after the settlement, I had a visitor. An elderly Asian man knocked on my door, leaning on a cane. It took me a moment to realize who it was. Mr. Chen. "Please call me Robert," he said with a smile. "I hope I'm not intruding. My son told me how to find you." I invited him in and made tea. We sat on my back porch, looking out at the pond. "It looks just like I remember," Robert said softly. "My father dug that pond in 1952, you know. He found the spring and decided to capture it. It's fed our family for 3 generations." "It's a beautiful spot," I said. "David told me about your troubles with the HOA. I'm sorry about that. When they first asked to use the overflow water, I thought I was being a good neighbor. I didn't realize they'd come to think of it as theirs. You couldn't have known." "I should have formalized it," he said. "Put it in writing, made them pay something, even a token amount, so there was a clear understanding. Instead, I was lazy and you paid the price." "It worked out," I assured him. "Actually, it worked out better than if they'd had a formal easement. Now I have an income from the water and they have clear terms about usage and access." Robert smiled. "My father used to say that water is life in the desert. He was right. Control the water. Control everything." We talked for a couple of hours. Robert shared stories about growing up on the property, about his father's work building the irrigation systems, about the years before the development went in, when it was just open desert as far as the eye could see. Before he left, he put his hand on my shoulder. "Take care of that spring," he said. "It's been flowing for probably thousands of years. It's a gift, a responsibility." "I will," I promised. After he left, I walked down to the pond and stood at the edge, watching the water flow from the spring. Robert was right. It was a gift and a responsibility. The fight with the HOA had been about property rights and legal principles, but it was also about something deeper: respect for the land and its resources. That fall, the local news did a follow-up story on the situation. They interviewed me, some Saguaro Heights residents, and even talked to some HOA reform advocates who'd used my case as an example of what could go wrong when HOAs overstep their authority. The reporter asked me what I'd learned from the experience. "I learned that you have to stand up for your rights," I said. "But I also learned that most people are reasonable if you give them a chance. The problem wasn't the community or even most of the residents. It was a few people in leadership positions who let power go to their heads." The story ended on a positive note, showing the community thriving with their new water agreement and highlighting the importance of clear contracts and mutual respect in property disputes. As the year came to a close, I reflected on everything that had happened. In a way, the fight had been worth it. Not because I enjoyed conflict, I definitely didn't, but because it taught me to value what I had and to defend it properly. The property meant more to me now because I'd fought for it. The pond was more precious because I'd protected it. The monthly payments from the HOA continued, a steady reminder that resources have value and that fair compensation for their use was just common sense. The new board ran things professionally, and I heard through the grapevine that several other HOAs in the area had revised their policies about water rights and easements, not wanting to repeat Saguaro Heights mistakes. In December, 2 years after I'd first moved in, I hosted a small gathering at my property. Friends from Phoenix, my attorney Marcus, Deputy Morrison, and even a few of the Saguaro Heights residents who'd become friendly acquaintances. We gathered around the pond, and I grilled fish I'd caught from the water, vegetables from my garden, and fruit from the orchard. As the sun set over the desert, casting orange and pink across the sky, Marcus raised his glass in a toast. "To Vincent, for showing us that standing your ground isn't about being difficult, it's about knowing your worth and demanding respect." Everyone drank to that, and I felt a warmth that had nothing to do with the Arizona heat. Later that evening, after everyone had left and I was cleaning up, I stood by the pond one more time. The water reflected the stars, and I could hear the gentle flow of the spring feeding it. My spring, my pond, my property. Someone had once tried to claim it wasn't mine, tried to bully and harass and even poison it out of spite. But the water still flowed, clear and clean and life-giving, and it would keep flowing, feeding my land and through our fair agreement feeding the community next door, but on my terms. With respect, with compensation, with dignity. That's how it should have been from the start, and that's how it would continue. The pond had taught me something important about life in general. Resources, whether they're water or time or talent, have value. Giving them away freely can be an act of generosity, but having them taken without permission or respect is theft. There's a difference between being generous and being taken advantage of. Brenda and the original HOA board never understood that distinction. They felt entitled to what wasn't theirs and couldn't comprehend why I wouldn't just surrender to their demands. In their minds, the community's wants outweighed my individual rights. But that's not how property law works. That's not how respect works. That's not how any functional society works. The legal system, for all its flaws and delays, had ultimately protected my rights. The criminal justice system had held wrongdoers accountable, and the market system had found a fair price for a valuable resource. Everything had worked as it should, eventually. As I locked up my house that night, I thought about how different things might have been if that first meeting with Brenda had gone differently. If she'd said, "We've been using overflow from your pond for years, and we'd love to continue that arrangement," what would be fair compensation? Instead of, "You have to let us keep using your water because we want it." One approach would have led to immediate agreement. The other led to months of conflict, criminal charges, and a complete change in HOA leadership. Pride and entitlement are expensive. The next morning, I woke to another beautiful Arizona sunrise. I made coffee and took it out to the porch, watching the desert come to life. A family of quail scurried past, heading for the pond. A hawk circled overhead. The spring bubbled up, constant and reliable. My phone buzzed. It was an email from the HOA treasurer, confirming that month's water payment had been processed. $3,000, right on schedule. I smiled. The system worked. Justice had been served, and life went on peaceful and productive. The pond reflected the morning sky, and somewhere in its depths, I knew the spring was flowing just as it had for thousands of years before I arrived, and would continue for thousands more after I was gone. My job wasn't to own the water, not really. It was to be a steward of it, to protect it and use it wisely and ensure it continued to flow for whatever came next. That's what Robert Chen's father had understood. That's what Robert had tried to do. And that's what I would do for however long I lived here. The water would flow. Life would thrive. And no HOA, no entitled board president, no amount of harassment or legal threats would change that. I'd stood my ground. I'd protected what was mine. And in doing so, I'd created something better than what had existed before. A clear agreement, fair compensation, and mutual respect. That was worth fighting for. That was worth defending. And as I sat there watching the morning light play across the water, I knew I'd do it all again if I had to. But I hoped I'd never have to. Once was enough. The pond was mine. The water was mine, and they would stay that way. End.